Hi everyone, thanks for coming to my presentation. I might just acknowledge country. Ninari, Nalawangun, Maribajari, Gadi Narada. We sit down and meet on good Gadigal country, and I am coming from Gadigal country today, and I just want to acknowledge elders past and present. So today my presentation is called What Risk? A Critical Analysis of the Risk-Based Regulation of Therapeutic Goods. And my name's Christopher Rudge, and my details are on that slide. So risk regulation of medicine is really two things. There are two types of RBR. The first is the familiar kind. It is the risk-benefit analysis that the regulators do that involves considerations about safety and efficacy. But the second is slightly less well known, and it refers to an institutional approach to managing the costs of overregulation. This is actually known as risk-based regulation, or RBR, in the regulation literature. So RBR, as such, is directed towards rationalising financial and governmental resources. It aims for less duplication, more efficiency, and it seeks to limit state liability. Julia Black said in 2005 that the move to risk-based approaches to regulation stems from political and organisational pressures arising within regulatory agencies and demands from central government for more effective, particularly cost-effective implementation of regulation. So where did it come from? Well, in relation to biotechnology, in 1990, the US Office of Technology Policy announced a risk-based approach to regulating biotech. In order to ensure that limited federal oversight resources are applied, they said, oversight will be exercised only where the risk posed by the introduction is unreasonable. That is, when the value of the reduction in risk obtained by additional oversight exceeds or is greater than the cost that is imposed to get it. Politically, the policy was heavily influenced by the President's Council on Competitiveness, which was established in 1989. It developed through the 90s through the Reinventing Government and New Public Management initiatives, and it historically follows from the small and flexible government ideals of new public administration that arose in the 60s, but ramped up in the 90s following the US financial crash of the 80s. You can see here Al Gore and the President Bill Clinton in the early 90s standing in front of piles of regulation. And you can see on the right a book subtitled How the Entrepreneurial Spirit is Transforming the Public Sector. This was an attempt to reduce regulation. You can see here that the government awarded these framed hammers as awards to regulatory agencies. It had two real purposes. Firstly, the hammer symbolised smashing regulation. The second was that the hammer had reduced in cost from $400 to $6 as a result of reduced regulation. So that became this hammer award. The Reinventing Government and NPA movements of the 90s led the FDA in particular and its biologics division, the Centre for Biologics Evaluation and Research, or CBER, to adopt rules that reduced reporting obligations for the manufacture of biologicals, namely human cell and tissue products. This meant that pharma companies making biological therapeutic goods didn't have to report as often as they needed to, and that's an example of regulations being cut. The same thing was happening in the UK, where you had Sir Peter Gershon wrote a report in 2004, Philip Hampton in 2005, and the Better Regulation Task Force in 2005 too. The publication of the Hampton report, the middle one there, led Tony Blair to promise both an end to compensation culture, to remove the liability of government and stop government having to compensate people for whom it had been responsible and failed to implement regulations. And also, Blair promised the removal of regulation that was seen as a burden to those engaged in low-risk activities. Risk was at the same time foreseen and theorised in the sociological risk scholarship. You can see Nicholas Lerman and Ulrich Beck are prominent authors there. Today in Australia, regulatory impact statements are required whenever the government wishes to change laws, including therapeutic goods laws. This is run through the Policy Impact Analysis Framework, which is published by the Office of Impact Analysis in the Department of Prime Minister and Cabinet. You can see that the Policy Impact Analysis Framework involves this kind of mapped out flowchart And regulators are asked themselves 7 questions, including these 2 that are highlighted. Have you identified potential alternatives to government intervention is question 2. And question 3, it is often helpful to refer to the status quo as a base do-nothing case, and you're effectively justifying doing something at all. Henry Rothstein in 2006 spoke of the government removing the dilemma of imperfect control by anticipating the possibility of failure within decision making. Really, the message was, if you can't control it and don't want to be responsible for it, don't regulate it. This is the RBR approach. The New South Wales Civil Liability Act in 2002 and other similar civil liability acts around Australia made this law. In section 44 sub 1, it says a public or other authority is not liable for failure of the authority to exercise or to consider exercising any function to prohibit or regulate an activity if it could not have been required to exercise that function in proceedings instituted by the plaintiff. In other words, if there was no adopted position that we will regulate it, then no one can sue for a failure of a government agency to regulate it. This entered into the common law, and Gummow and Hayne, justices of the High Court, said in 2002 that the coexistence of knowledge of a risk of harm and the power to avert or minimise that harm does not give rise to a duty of care at common law. Those with statutory powers would otherwise owe a duty of care to those ultimately threatened by that risk to act or to prevent, to minimise a risk. So the common law also recognised that where risks were not legislated, then the government owed no duty of care. So today I'm going to be talking about 2 case studies in relation to risk-based regulation. The first is based on stem cell medicine, and the ultimate learning is that in pursuit of non-duplication and cost-effectiveness, exclusions result in under-regulation or sometimes inapt regulation. The second is about mRNA vaccines, and the lesson here is that because risk-based regulation driven regulatory exceptions are prospective, i.e. they are written before they apply, this means that emergent technologies are not often captured, and the regimes must be applied, therefore, purposively, and this can result in disputes and confusions. I'm not going to be talking about osseointegration devices today in the interest of time. So in the first case study, stem cell products, we can see that the TGA takes a risk-based approach for regulating stem cell products. It says it on the website. Autologous stem cell products are regulated by the TGA, but the agency's approach has made certain stem cell products reclassified, excluded, or exempted as low-risk products. This is the RBR approach. It's about de-responsibilization. Thus, products that would normally meet the definition of a biological under Section 32AA are either reclassified as therapeutic goods rather than biologicals, they are excluded from the therapeutic or from the biologicals framework as something that is low risk, or they are exempted because they are administered by a health practitioner and the risk involved in the administration of the therapy is displaced to the hospital or to the practitioner. Each of these manipulations has undesirable consequences, but the last one we looked at, which was about risk displacement, has permitted medical practitioners in private clinics to run clinical trials with unregistered stem cell products. Apart from being ineffective, the unproven and unapproved therapies are dangerous where small clinics are responsible because there's no hospital oversight. And in one example, a practitioner infused a patient's own adipose-derived stem cells into the patient's brain. This patient died of blood loss from that surgery, but she also probably would not have benefited from the hypothetical glial cell regeneration that was intended by the practitioner because there's just no scientific evidence, trials or mechanistic studies supporting the therapy. The TGA's policy explanation about their decision not to regulate these so-called low-risk stem cell products is as follows. They say the level of regulation for autologous HCT products is based on the level of risk to the public. The TGA considers that there are circumstances in which there is sufficient regulation by other bodies to mitigate possible risks. So this is risk displacement, and the other body here is a hospital or a medical practitioner. This is de-responsibilization by the TGA. It's not a secret, it's not an accusation, it is just part of risk-based regulation. And we also see the displacement of responsibility from the regulator, the TGA, to the private sector, in this case private medicine, or it might be to a state government public hospital. The second case study is on mRNA vaccines. So firstly, legal action was commenced this year against Pfizer and Moderna in the Federal Court of Australia, where the litigant sought an injunction on the supply of vaccines to stop them being supplied. The applicant's contention was that the manufacturers required a license from the Office of Gene Technology Regulation for the vaccines under certain sections of the Gene Technology Act, but that the manufacturers did not obtain one. In my view, these submissions are not even minimally adequate because the application makes no reference to the gene technology regulations that sit under the Primary Act. And these regulations exclude certain products from the agency's regime, including, in my view, the very mRNA vaccines that are contentious. The litigation, therefore, reflects a deep confusion among the public, among some lawyers and some politicians about the operation of the scheme. It has led to misinformed questions being asked in the Commonwealth Senate of the regulator, several conservative news sources covering the story and repeating these misconceived allegations, and it's even led to the drafting of a criminal brief forwarded to the Attorney General and the Australian Federal Police, alleging that the regulator has criminally breached the Gene Technology Act. Now, as I say, my view is that the litigation is meritless, but legal scholars have identified some value in meritless litigation because it may, for example, in the highlighted text here, play an important role in a discussion of the proper institutional conduct and behaviour. In my opinion, this litigation recasts a classic problem that we all have heard of, described in Mount Isa Mines by Justice Windeyer as law marching with medicine, but in the rear and limping a little, has today come a long way. In other words, medicine moves fast and innovates, and the law has to catch up. In the RBR context, the GT regulations that I talked about earlier exclude several products, as I said. They exclude certain things that might apparently be genetically modified organisms through what I'm calling definitional riders and by express inclusions and exclusions. The object of the Act is to protect the health and safety of people as well as the environment by identifying risks posed by gene technology and managing them through dealings with genetically modified organisms. So the definitional riders are like so. You can see that some of them say GMOs do not include, and they'll say an organism declared by the regulations not to be a GMO. And then when we look at the regulations, you can see Schedule 1 here, organisms that are not GMOs are written down. And then we have techniques that are not gene technology are also written down. Now, the litigation and criminal complaint do not even contemplate these exceptions. But the exceptions were not crafted around mRNA. And so the law could arguably be said to be limping in the rear of the vaccines when they arose. Still, when we adopt a purposive readings of the exclusions, the mRNA vaccines are clearly approached or covered by these exceptions. There are two exceptions that I think arguably apply very well. There are some problems with them as well, but I think they are overcome when we take a purposive reading. In fact, what I think we find is that the purposive reading of laws and regulations, including those about therapeutic goods and genetic technology, is the proper approach, as was confirmed by the House of Lords in Quinterval and Secretary of State back in 2003. And the relevant ratio from that case was approved by the High Court in a leading plurality in the 2008 case of Griffiths and Minister for Lands. Gummo, Hayne and Hayden, the justices, adopted the reasoning of Lord Bingham. And in an article in 2003, Kathy Little talked about purposive interpretation and the march of genetic technology, citing Quinterval, but that arose before Griffiths. Unsurprisingly, those that advised the OGTR about how the regulations should apply and how certain technologies should be regulated, namely the Gene Technology Technical Advisory Committee, have confirmed that mRNA vaccines are not GMOs. And you can see that there in that highlighted text. However, these case studies, both the stem cells case study and the GMO case study, shows how the modern risk-based regulation model presents problems. Where regulators de-responsibilize through exemptions and exceptions, or through co-regulatory risk displacement, the exclusions may result in under-regulation or inapt regulation, or because the regulations are prospectively written, they may be read and apply purposively, but this may result in disputes and confusion among members of the public. That's my presentation from today, and I hope you enjoyed it. I hope that it was interesting, and I look forward to questions. Thank you.